Hello, we are Raiden, Matthew, Nora, and Shan. The topic now we are covering is the Consumer Guarantee Act, which applies to both consumers and business. The CGA, by default, applies to all people who purchase the goods of a kind ordinarily used for personal, domestics, or household use.
Definition of a consumer, as per the Consumer Guarantees Act 1993 from the legislation website, is a person who acquires goods and services of a kind ordinarily acquired for personal, domestic, or household use or consumption, and does not acquire these goods or services for the purpose of the following: resupplying them in trade, consuming them in the course of a production process or manufacture, and in the case of goods, repairing or treating in trade other goods or fixtures on land. It is also important to note the definition of acquiring, which is to obtain by the way of gift, purchase, or exchange, and includes lease, hire, and hire purchase. The guarantees given to a consumer by the CGA in 1993 are dependent on whether the product is a good or service. Guarantees given for goods include acceptable quality, fit for particular purpose specified to retailer, match the description, match the demonstration model or samples, reasonable price, delivery must be on time and undamaged if the retailer arranges delivery. The manufacturer must honor express guarantees. There must be sufficient spare parts and repairs available. And with respect to services, guarantees given are reasonable skill and care taken by the service provider, fit for their particular purpose, completed within a reasonable time if a time frame has not been agreed upon, reasonable price if a quote has not been given, or payment otherwise not prior agreed to.
When consumers are unsatisfied with their goods, they have several rights under the CGA. The consumer can go to the retailer, supplier, to remedy the problem. If the supplier/manufacturer refuses to remedy the problem, then the consumer can take the issue further, for example to the disputes tribunal. The supplier has the right to try and repair the goods if there is not a failure of substantial character, which will be discussed later. If repair is not possible, or if the supplier does not remedy the failure within an acceptable time frame, the consumer has the right to reject the goods and ask for a replacement or a refund of the purchase price. A failure of substantial character can include not matching the description in significant ways, being unsafe, not being fit for the intended purpose, or if the goods would not have been acquired by a reasonable consumer. In this case, the consumer again has the right to a refund or a replacement. Additionally, there is the concept of a consequential loss under the CGA, where if there is a loss caused by the failure of a good that was reasonably foreseeable, the consumer can claim damages. However, it must also be noted that there are circumstances in which the consumer cannot claim under the CGA. Specifically, if usage of the goods by the consumer is inappropriate or excessive, that is, a reasonable consumer would not have used the goods in such a way, or if the supplier had specified defects with the products prior to the consumer purchasing said products, and the consumer had acknowledged and accepted these defects, there may be no remedy for the consumer under the CGA.
The Consumer Guarantees Act applies automatically to all consumer purchases of goods of a kind ordinarily acquired for domestic, personal, or household use, and this includes businesses that purchase goods for these reasons. However, it is possible for the CGA to be contracted out of in specific scenarios. The conditions to contract out of the Consumer Guarantees Act are: it must be a business-to-business contract, both parties must be in trade, the agreement to contract out of the CGA must be in writing, it must be fair and reasonable for both parties to be held by the contract. Other than this, it is not possible to contract out of the CGA, as it is an offence against Section 13 of the FTA and carries the associated penalties.
The Consumer Guarantees Act has serious implications on the way businesses act in New Zealand. Consumers enjoy security when purchasing goods and services, as they know that if there is a problem, it is likely to be covered under the CGA, and that they will be able to claim under this legislation. In contrast, other countries have poor consumer protection rights, hence caveat emptor, let the buyer beware. In addition, if there are problems that arise with their supply of goods or services, businesses must remedy these problems much of the time, unless an exception applies. This means that businesses may be liable for losses due to defective products. Moreover, businesses will often have increased costs due to the requirement of having a customer service department that deals with such issues to meet the obligations of resolving problems in an acceptable time frame.